Okay, so the first thing I'm going to talk about, actually, as we frequently do, is a little bit of housekeeping, and that housekeeping having to do with the other class that we have to make up. I have the flexibility to make up one class, but sadly not two in a row. So the one class that I was able to accommodate without having to do a reschedule will actually be the material that I would have covered after the content for this class. So today we're going to start to talk about case research. The following class would be basically updating your case research and making sure the case you rely on is still the holding you still rely on is still good law. So to do that, this handout, which is also on TWEN here it's in a couple of places actually, but in the screencasts section here, and you will find the handout here. So basically what I'm going to ask you to do are view three different parts. So the first part is Lexis Learn. Lexis actually has some, I think, really neat videos. Open up and see if I can get there real quick. So what you need to do is, when you get into Lexis, which will hopefully happen in a minute here, so you see Lexis Learn up here. So once you've logged in, I'm logged in as me, so it's going to look a little different for you. But once you've logged in to Lexis Learn, you'll see these screenshots here. If you haven't done so before, you'll want to click on Add a Class. And then you'll see the various instructors, you'll see my name, and you'll just walk through and add Advanced Legal Research. And for the makeup, I have assigned 2 of the modules. The modules, it depends on, walking through the modules, there are points at which it asks you questions, so it depends on how long you take. But the actual recordings are about 10 minutes, and then however extra it takes you to answer the questions will be how long it takes. So each module is about 10 minutes. So the first one is making sure you are citing good law, and the second one, finding more authority. Hopefully the handout's pretty straightforward, and as I said, it's also here on TWEN in the screencasts as well as the handouts. But in the screencast, you'll see the Lexis Learn instructions, you'll see the link, and you will also, in the screencast, see the links to the other parts of the makeup. So that's the first part. Then we have the screencast that we've done before, that I've done through TED-Ed. I appreciate your referencing TED Talks, but they're really not TED Talks. You won't find them there. This is just through TED-Ed, so just like you've done, actually looks like I have to make those available to everybody. I will do that. It was supposed to have happened. Anyway, I will do that. They will be available by the end of class. So basically there are 2 parts to the makeup, and I just ask you, as you've done with the TED-Ed screenings before, just to view the video and then answer a few questions. All of this, as Matt, you noticed, is set forth here on the home page. So Lexis Learn modules, and then the TED-Ed Screencast Part 1, TED-Ed Screencast Part 2. And once again, as always, if any of this seems confusing, just let me know and I'll get back to you as soon as possible. As I said, each of the Lexis Learn modules is about 10 minutes. Each of the screencasts are about a half an hour. So this whole process, I don't think, will take you much more than 2 hours. So it's a little shorter than class would have been. Questions? Okay, let's then dive back into what we are covering today. And part of the reason I wanted to schedule this makeup in class and schedule it before spring break is that the material we're going to cover, as I said, is some of the basics of what you all will be doing, and that is finding cases. I know you've discussed researching cases back in 1L year and perhaps after that, but I think going over some of the techniques, and I will hopefully be able to introduce you to some new techniques you didn't know about. But what we're first going to do is take a look. Once again, we have a walkthrough, and again, this is also on the handout's link. We're going to go back to some first principles, and the reason we're going to go back to first principles is basically to get you to think about what you are looking for when you are looking for cases, when you are researching cases. So the first question to answer is, why do we care? Why are we researching cases?
Finding principle, interpret statutes. I mean, it's the standard for which you have to operate.
So basically, remember in first year what we called it?
Primary sources.
Well, definitely primary sources, but what was the principle? Stare decisis. And stare decisis is? So in an oversimplified, and we're fine with that here. Don't say this to your other law professors, but we're fine with it here. Basically just looking back to the concept of finding prior precedent to establish what the law is and possibly to refute your opponent's arguments. So again, as we talked about, back to our sources of the law handout here, so we have moved from the legislative branch to the judicial branch. And what we need to think about as we think about looking for that precedent is the structure of the judicial branch, the structure of the courts in your particular jurisdiction. And yeah, this is definitely, as I said, way back to first principles, first year. So again, in a very simplified version here, bless you, on the sources, we have, of course, the levels of courts. So you have to obviously think about that, as we all remember from first year. And so I'd like to point out, although I'm sure you've all talked about this at length, pretty obvious. We all know what they are on the federal level. It's always a little bit confusing, especially to first years. If we remember way back when, trying to figure out why on earth the Supreme Court in New York is the trial level. And I don't have an answer to why they called it that, but obviously you need to be aware, depending on what state you're in, what the different levels of courts are. So here in New York, for whatever reason, the trial court, Supreme Court, the appellate division at least has an understandable, intuitive name. And then again, for some unknown reason, the highest level in New York's Courts of Appeals. So again, in terms of keeping that principle of stare decisis in mind, in terms of looking what is precedent, what are those cases that we have to pay attention to, let's take a look at that concept of hierarchy. And what we'll see in the walkthrough, if you take a look, we are actually looking at probably what for some of you was your first year text by our very own Professor Newman and a colleague of his. We're looking actually at the older edition, which actually you may have used because the newer edition just came out this year. But I'm looking at the older edition because it actually goes a little bit in more depth than the newer edition. I can understand why they simplifies the newer edition because that's really for first years, but for our purposes this will work pretty well. So on page 2, we will see a chart, perhaps you remember this from first year, which sets forth primary authority and the hierarchy of that primary authority. And what I particularly like about this chart is we see in that box on the left, the hierarchy and the concept that all of this is primary authority because it's that authority that governs the court in which your lawsuit will be decided. And that, to me, is a wonderfully descriptive way of understanding what it is we have to think about, and I think a really effective way. So we've already talked about primary and secondary authority at length back at the beginning of the course, so I'm not going to worry about that unless there are questions, of course. But let's talk a little bit about the mandatory versus persuasive authority, and of course it depends on your jurisdiction largely. So obviously here in New York, we might look to New Jersey cases, but we're not really, or New Jersey statute, but obviously we're not bound by them. But what is mandatory authority within your jurisdiction? And that's what we're going to spend the next few minutes thinking about. Again, because as we research cases, we have to know what cases are going to have what effect on for our clients. Okay, so here again on page 3, I've underlined the prominent concepts. So generally speaking, a court is bound only by decisions from higher courts within the same jurisdiction. So we've already kind of established that. Again, first-year principles here in New York. I'm going to be focusing on New York because I think we're all pretty familiar with federal, although we'll look at federal in just a moment. So here in New York, pretty straightforward. Courts of original instance, appellate courts, Court of Appeals. We already talked about the silliness with New York's names, but again, I think that's pretty straightforward. And as I mentioned, we're focusing mostly on New York, but just to briefly look federal, we've got our various circuits. Again, I'm sure you remember this from first year. We, of course, are in the Second Circuit, so only district courts within our circuit would be bound by courts of appeals, federal courts of appeals decisions. So again, we see that. And these charts, by the way, because I know this screen isn't always the easiest to see, the first chart we saw is on page 8 of your handout, and this chart is on page 15. So if you want to see it in detail, that's where you'll find it. Okay, so again, back to page 3. So we have, again, the basic principle, courts of appeals, decisions find only the federal district courts within its circuit. Courts of appeals do not bind state courts or each other. So again, basic principles just to set forth. So here's where it starts to get a little more complex. Back to civil procedure. I'm sure you all remember Erie with great fondness. The Erie decision as state Supreme Court binds all lower courts in that state on issues of state law. Under the Erie doctrine, state appellate courts bind any federal court applying that state's law of diversity jurisdiction. So again, now you need to think about, okay, if I'm looking at a federal court and it's to figure out is it a diversity decision, then what's binding is the state court's appellate decision. And then finally, a state's intermediate appellate court binds any trial court in its jurisdiction. Straightforward, we've already established that. Some states are divided into more than one appellate jurisdiction. Welcome to New York. In that case, the intermediate appellate court might bind only those trial courts in its jurisdiction or all trial courts in the state. And the reason I'm going into more detail is we are in a state, again, welcome to New York, where we have different departments. So as we start to think about being in different departments and what cases are mandatory authority, we'll talk about that, but let's hold that thought because I want to just make sure we're thinking about hierarchy of primary authority before we dive into the details of departmental authority. And that chart pretty much set forth. If you turn to page 4, sort of have the text description of what we already saw on the chart. So Constitution, not surprisingly, fails over inconsistent statutes. Either a Constitution or a statute prevails over inconsistent case law. I think sometimes law students forget that because you spend all your time reading cases and you think, well, that's what's important, right? Well, actually, a statute's going to prevail over case law, as well as court rules, which you'll hear about in the screencasts that will be for the makeup class, administrative regulations, and agency decisions, which we'll talk about after spring break. So statutes prevail over all of those other sources of primary law. So again, think about as you're reading all of these sources, which is going to have authority. And again, just as statutes trump the common law, which is one reason why I try to suggest to you that when you're not familiar with an issue, you want to see if it is a statutory issue before you even dive into researching case law, which is one reason why it's not always a good idea to start your research in case law. Okay, so basic principles. Let's now move to, oh, and I should mention before we get there, so in this arrow here in the italicized of the handout, any new statute trumps any prior inconsistent statute. Regulation agency. Okay, so as we already said, within the same jurisdiction, a decision from a higher court outranks a decision from a lower court if, and this is the key principle, and this is what is going back to that little phrase in the little square chart, and this to me is the best way to understand as we start to look at the details of what department decision has authority over what court. So within the same jurisdiction, a decision from the higher court outranks a decision from a lower court if the higher court has the power to reverse the decision of a lower court. So if your issue is in a lower court, if that issue gets appealed, where will it get appealed to? And that's the court that has authority. The newer edition of this text actually has one phrase that I was almost tempted to copy the page and put in, but it might have been too confusing. But what it said was, imagine you're a judge, and maybe someday one or more of you will be a judge. Imagine if you were a judge, where would your decision be appealed to? And that's the court that's going to have authority. And I thought that was a really good way to think about it. And also, always remember, within the same jurisdiction, if a higher court overrules one of its own prior cases, so U.S. Supreme Court, New York Court of Appeals, or if it decides a case in a way that's inconsistent with one of its own prior decisions, the prior decision is no longer valid, which again is why we need, one of the reasons we need to update, and update. Okay, so let's dive into New York and the fact that we do have different departments. And oh, look, it's snowing. Talk about it as we were talking about and complaining about. Go away. Okay, but back to decisions and departments within New York. So on page 6, what we see is actually from the New York Legal Research Guide I showed you a couple of weeks ago, and it actually sets forth the different courts in New York. So you can see the hierarchy toward the bottom of the page. And what it says here on page 7, the route to appeal in New York is fairly complex. So even this text is saying it. So if you are a little bit confused, welcome to the club. In general, the appellate terms and appellate sessions of county courts, so they're two different, slightly different things, hear civil and criminal appeals from the local, in quotes, inferior courts. The appellate division hears appeals from the superior courts in civil matters and from the county court and Supreme Court in criminal matters. Anybody confused yet? I am. Okay, the point here, I am not going to be able to clarify that because it honestly is going to depend where you are starting in terms of where your case goes and where it might be appealed to. The point is, think about it. Hopefully 90% of the time this is not going to be an issue, but there's going to be some instances where you are going to need to think about what court you're going to start in and what court has appeal jurisdiction to the court you are in. And just to give you a sense of what that might look like, so those are just the list of departments. So here is a more in-depth court structure, and that is on page 9. And it's really involved, as you can see. I'll scroll down here so you can see it on the screen. But here on page 9, and this looks complex, and it took me a while to figure it out, but if you follow it through, it actually does give you a good explanation. And again, I don't expect you to understand all this. Certainly for this course, I don't understand this. The point is to ask yourself the question when the time comes and then figure it out. So here in New York, just to give you a sense of the general structure, where are we here? So we have 4 departments here in New York. Nassau County's in the 2nd department. If you practice in Manhattan, that's going to be in the 1st department. And you can see there are different judicial districts within the different departments. So here in Nassau, we're in the 10th Judicial District. The district question goes less to authority and hierarchy of the courts and more just what court are you going to start your case in. Okay. So the appeals taken, as we see on page 7a, appeals from the superior trial courts, are taken to the appellate division. Appeals from the lower trial courts, so their lower specialized court, like family court, district courts, are handled differently in the departments. And again, don't stress over what happens where at this particular moment. Just be aware that it might be a question. And you see on page 10 a map that might give you a better sense than the lists. Okay, and finally, on page 11, you'll see the departmental list that I just mentioned. So finally, on page 12 comes from our good friend New York Jurisprudence. And I think this will hopefully give you a sense in terms of what we need to think about as we're researching New York cases in terms of the different departments. So on page 12, toward in the last paragraph on page 12, in the middle, where there's a conflict between decisional law of the courts of appeals and that of an intermediate federal appellate court. So again, we're talking about Erie here. The ruling by the state court of appeals should be followed by a lower New York court. So if you're in if you're looking at a lower New York court decision, it's going to be the Court of Appeals that's going to be the authority rather than a federal appellate court. Now, as to the difference between the departments, if you go to page 13, where a question has not yet, underlined here, where a question has not been decided by the appellate courts in a certain department, inferior courts in that department must follow the determinations of the appellate courts in any other department until such time as their own appellate tribunals or the Court of Appeals passes upon the question. So, if we're in a we're in the second department. So if we go to a trial court, we're going to look to the second department appellate division as our higher court. So if there's a decision in the, if we're in the trial, if we're researching our issue, so if we're researching our issue for our client with regard to liability HMO and we're interested in New York law, if there is a decision in the second department appellate division and there's a contrary decision in the third department appellate division, we have to follow, we're going to cite as authority the second department if there's a conflict. If there's no decision in the second department, remember, we're in the second department, but there is one in the third, what I just read says, all right, we actually got to follow the one in the third because there's nothing yet in the second. So until there's one in the second department where we are, or until there's a court of appeals, which controls all the departments or is authority for all of the departments in New York, we would look to other departments, but other appellate division department decisions, but only when there's nothing in our appellate department. And if you think about it, that goes back to that principle that I thought was so useful that we first looked at either in the box or I mentioned was stated by Professor Newman in the new edition. If you're a judge in that court, so if you're a judge in a lower court in New York, you're going to look to your department's appellate division, right? If nothing's in your department's appellate division, then you would look to the other department's appellate division. And of course, the Court of Appeals is the highest court in New York, so we all look to that court. So of course, that court has authority for us as well. So this was a little bit more detail than you probably expected with regard to stare decisis. But again, as we look at cases, you may need to think about, if you see two different cases in New York that seem to conflict, you want to start to think about what department they're in. You want to start to think about what department they're in, even if you don't see cases that conflict, because you want to be aware, if we're in the second department and a case you are citing is in the third department, you want to be able to argue, is that authority or isn't that authority? Questions? Questions?
So, if your department has not addressed an issue, and you look to the other one, do you look to all the rest of the three, or you? Because I see multiple times in state court cases, like they'll address the third appellate division, fourth appellate division. Like, does it really matter, like which one you cite?
As far as I know, once you are outside of your department, so we're in the second department, the first, the third, and the fourth are equal. Excellent question. Any others? Okay. So we've talked about authority and what we are looking at in terms of authority when we are researching. Let's now talk about how those cases wind up as authority in whatever jurisdiction, and that has to do with publication. So when we talk about case law, when we talk about precedent, when we talk opinions, we're typically talking about published cases. And published is probably an antiquated term these days because so much is online. And what happens is, because it's online, we think that, oh, that's an officially published case. Well, that may not be true. Many non-lawyers don't even realize that most cases that go before, especially trial courts, never become precedent or law, never become published. And I'm going to probably inadvertently use the term published to be equivalent to precedential. So if a case is published, that means that is precedent. That is something that you can rely upon as what we're calling common law as part of the principle of stare decisis. So many of those trial courts and sometimes even appellate level judicial decisions do not get published. They are considered to be unreported. And one of the, pick up some handouts. One of the handouts is this article from a couple of years ago. Now this is about federal courts, and it talks about how within the federal circuit court, so the Circuit Court of Appeals, the appellate level, 88% of decisions issued by federal appeals courts are unpublished. So for a variety of reasons, those judges decide they don't want to publish their decision, which means their decision is not precedent. It cannot, it will not be binding on the lower courts within its department.
Sorry, I just got here and I want to ask a question about that. Why would they want to do that?
If you read the article, one reason is because they have to put in a whole lot more effort into writing the decision to make sure that it is going to not confuse the state of the law in that particular area anymore. So it takes a lot more time and effort to write an opinion that does become published than it does just to write a decision that, while it might be cited, and we'll talk about citing unpublished opinions in just a few minutes, but it might be cited as persuasive authority. Hey, look, the judge did this and this other, so it's a good idea, but it doesn't have to be followed.
So it's not that you can't use it, it's just that it's not mandatory.
Exactly. So I'll dive right in instead of putting it off. So in federal courts, and I have to write this down because I never remember the rule number. So in federal courts these days, if the opinion is 2007 or later, the Federal Rules of Appellate Procedure 32.1, and you can write this down, but it's not necessary, says that you may cite to it. But just, you said it perfectly, Mary Ann, it is not mandatory authority. You can cite it and say, hey, it's a really good idea, but the judge doesn't have to follow what that unreported decision said. You want to check for federal rules, you want to check your particular circuit's rules if you have a pre-2000 decision that you want to refer to that's unreported. And for states, and again, a little bit ahead of myself, but that's okay, each state has different rules. So what I'm putting up here on the screen is a chart that was put together by a librarian back in 2008. So it may be out of date, but I have been unable to find an updated version, so this at least is a start. So states have different rules about whether you can cite to unreported cases as precedent, as mandatory authority. Here in New York, I believe the answer is yes, but it's not binding. So not precedent, so again, not mandatory authority, although entitled to respectful consideration. And here's the reference. Now, Alex, since you are here, so in Louisiana it says, and now this is from 2008, unpublished opinions shall not be cited, quoted, or referred to. So again, I don't know if this is...
do it, but yeah, we have jurisprudence constant rather than stare decisis, which is there has to be the same decision multiple times before it becomes binding.
Because you're a civil law jurisdiction.
The courts will refer to, unpublished opinion, but decision all the time. It's virtually common law.
So it sounds like this is more the practice more in the breach that it's not supposed to be referred to. And again, this may be out of date. I don't even know if that rule has been officially changed or not. But okay, so what can get confusing with this published versus unpublished or unreported is you go on Lexis and Westlaw, which many of us do, and you see the case. And again, this is you need to be bibliographically aware, a bibliographic awareness concept. So here on Westlaw, looking at a case, how you tell something is unpublished a couple of ways. One is that there's no official citation. You now all are familiar enough with official citations, FSUP for federal, NY, New York SUP is the unofficial. So here all I see, it's a 1996 case, all I see is a Westlaw site. Sometimes what you will see is some notice here. This is unreported. Don't rely on this. Be careful because this is easily confused with a very recent case. Very recent cases, they just haven't gotten around to assigning it its official site. So here's a 2018 case. And this one may or may not be published. We don't know yet. February 14, 2018. And obviously the way you tell is by the date. How recent is it? Here's an example where I think Lexis does a better job, because here you see that notice. Not approved by reporter of decisions for reporting in state reports. Whereas a very recent case, we have again a notice. Pagination of the document subject to change pending release of the final published version. Uncorrected and subject to revision before publication in the official reports. So look for the notice. If you don't see it, then look at the date. And as I mentioned, reported cases wind up sometimes in several different versions. Some are official, and you all who do Blue Booking know this better than I in terms of what the Blue Book rules are. So there's the official reporter, the state's published reporter, and then there's the unofficial reporter published by a commercial publisher in, typically that would be West. So on page 16, we see the regional reporters. So you're all familiar with Northwest, Atlantic, Southern, and this is just the map of what state goes into what region for that West National Reporter System, and they are not always logical, I have to say. I just thought it was interesting. New York goes into Northeastern, but anyway, you can have that debate if that interests you. How cases are reported, and the only reason this is you care, I like to answer the question, why do you care, is you will still see this terminology online. So I don't even think these exist anymore, but back in the day, cases first came out in something called a slip opinion. And this is an old slip opinion of the Supreme Court of the United States. These days, obviously, this winds up online all over the place. The Supreme Court website, as well as a whole bunch of other places as well. Anybody remember where else we heard that terminology slip for something that first comes out in the old-fashioned days? Slip law. And again, that terminology is still used for a law that first gets passed before it gets codified. So you will see the term slip opinion even online. I guess I'll just keep the old terminology because that's what people are used to. Let me back up a moment because I wanted to point out, because we had the very excellent question of why do judges not publish their opinions? Here in the federal system, as I understand it, the judges get to decide, but I'm not 100% sure of that. In New York, there is a particular division within the judicial system, a state reporter who makes those determinations. And here on the New York State Law Reporting Bureau website, you actually see the description of how that works, which is kind of interesting. And these links, by the way, to the New York Court website, as well as the maps, are all in our links section of the TWEN site. But again, back here on the selection of opinions, scrolling down, you can see some of the ways that the New York Law Reporting Bureau determines whether a case is going to be published or unpublished. And I imagine judges also, to the extent that they have input or make the decision, what they use to make that decision. So precedential significance, the novelty, public importance. So you can see those bases for that published versus unpublished decision, a determination, excuse me, I shouldn't use the same word. Okay, so we talked about where cases are published, official state reporters, for federal, obviously FSUP, FSECond are published by West, but there still are official reporters, so there's no hard and fast rule about who publishes the case reporter as to whether it's official or unofficial. One thing I do like to point out, because this question occasionally comes up as you are doing research, you might run into some really old-fashioned references or case citations. And if you take a look on page 17, way back, a couple hundred years ago, you had people, men, I think mostly, if not entirely, sitting in courts and taking notes about what was going on, and then they would publish their notes, and that would be the opinion. That would be the opinion. It wasn't actually written by, the opinions weren't actually from the judge, published, that were written by the judge. And those reporters were the names of those people who sat in court. So you can see in the Supreme Court, way back in the 17 and 1800s, there was Dallas and Cranch and Wheaton, and you'll occasionally see those citations, 1 Dal 47 or whatever the citation is. And here's a little chart. There's a slight mistake in the chart. The Cranch is actually 1801 to 1815. The website has been updated, but that was a typo in this handout. And you can see the translations. Those cases basically got translated over to the official U.S. reports. Where you're more likely to see that is here in New York, and I actually don't know if this is true in Louisiana or not, but in New York you will occasionally see references to these various names of these people who sat in the court. The term for this is nominative reporter, in case you ever run across that. So you might see citations to Keynes or Johns, and these are the list of people who authored those reports. And they typically do have translation into what's now the official New York system. So the NY, you can see the correspondence to the NY site. So again, just in case you ever run across that, basically the guideline is if you see a weird site, it's probably nominative. And if it looks like a name, then it's just an old case, and you'll actually notice that, oh wow, that case is from 18-something. That's all it is. And there's usually, as I said, a translation into the now, the system we use now in terms of NY or the Supreme Court. Okay, a couple of other aspects about where cases are published that you should know about. Anybody here of the federal rules decisions? Federal rules decisions, actually an official reporter, abbreviated FRD, because West publishes, is the official publication for all of the district courts, the federal district courts, FSUP, we all know and love. But there are so many decisions having to do with the FRCP, Federal Rules of Civil Procedure, that West decided quite some time ago to separate them out into a separate reporter. So you will see decisions with the citation FRD, and that's all it is. And you can see an example up here of a particular case that has to do with one of the federal rules. Actually, these are evidence. Another specialized reporter, if you wind up practicing in the bankruptcy area, there's the bankruptcy reporter, BR. Those are the two main ones. There's another reporter, education. Those tend to be more specialized. Some of these cases, including the ones that wind up in FRD or the bankruptcy, may also be in FSUP, so you'll see parallel citations. But sometimes the only citation you will see will be those reporters. And now you know what they mean. Yeah?
Are those government reporters or are those private reporters? like they find them and put them in because they think they're important, or are these from the government and they think they're important?
Okay, so Bankruptcy Reporter and FRD are published by West, but they are published, they are official published precedential cases. So whatever the federal system is, and as I said, I think the judges are involved, but I actually don't know the details of exactly how the federal judges make the determination about what gets reported. There may be a judicial, there's all sorts of judicial organizations, and they may be part of that as well.
Well, I guess the question is, I know like other like organizations put together, like I don't know if they're considered reporters, but they're groups of cases that they think are important for that industry, and then they have like their own, I guess, binders and get updated. So how to like gather those before? I guess that's my question.
So maybe this will answer your question, because I was about to talk about, let's see if I can find the right case for it, Lexis. So here's an example of a case that was published in the US PQ Second, which is a BNA publication, so US Patent Quarterly. It's also published in the standard place. This happens to be a Supreme Court case, as you can see. As you quite rightly point out, different publications will quote unquote publish cases because it's of interest if you're a securities attorney, or if you are a bankruptcy is a bad example, if you're a patent intellectual property attorney. So they get published in these newsletters, what they, old-fashioned paper, what they used to be, now they're online. They will typically, if they are published decisions, they will wind up in a published reporter like FSUP, like Supreme Court, U.S. So obviously U.S. is official, SCT is the West unofficial equivalent. Again, you Bloomberg experts understand that better than I. So they will wind up in those newsletters. If they are not published, they will not wind up in any of the official reporters. So the official reporters, again, U.S., maybe going back to the sources. I glossed over this, but so U.S., so F, third, second, first, whatever it is official for the courts of appeals, and FSUP, again, first, second, third, official for the district courts. Now, FSUP and F3rd are published by West, technically, but they are still official because there's no other. In New York, we have NY 3rd, and second and first, that's government. And by the way, for states, the highest court abbreviation will be the state's abbreviation. So NY, LA, CT, or CON for Connecticut. The lower courts in any state will have different abbreviations. So AD is, Appellate Division is the official for New York. The unofficial, again, is that West Regional that we looked at. I should also mention this. West Regional, we talked about Atlantic, Southern, Pacific. West also publishes what I think of as a regional reporter for California and New York, just because we produce so many cases. So they pull those out separately, and I think also because they can make money off of it. So there's also a New York supplement, which is what NYS is, or NYSUP. There's a California reporter, also a West, quote-unquote, regional as part of this whole regional unofficial system. New York also appears in, as we said, the Northeastern reporters. So this unofficial place, but these are all official reports as determined, at least in New York, by the New York Law Reporting Bureau, and from the federal end by the judges and whatever other organizations make that decision. So they appear in the official reports. If they wind up in those newsletters, that's just another parallel site. So if we go back to this case, you can see there's U.S. reports, Supreme Court Reporter, the West, Lawyer's Edition, a third place, Lexis's competition to the Supreme Court Reporter, so a third place. Then there's the original Lexis site. Remember, when a case first comes out and it's very new, it gets a Lexis or Westlaw site. And then another place, U.S. Patent Quarterly, And yet another place where another newsletter, U.S. Law Week, also put out by BNA. And then actually a few more places, because there's a case, when a case is of interest, the various newsletter, the specialized industries that you point out, publish them all over the place. That answer your question? Good. Okay. So there are also various places you will find unreported cases. Sometimes these again, by unreported, I mean not precedential, I mean cases that will never be published in an official. Sometimes they start out that way very new, like this one did, but for an example, do I have that here? Yeah, here we go. Here's an example on Lexis. There are a number of cases that get published in the New York Law Journal. And this, for states, this tends to be one of the places where unreported cases, where you find unreported cases that stay unreported. So the New York Law Journal, so it's this basically the state's newspaper, legal newspaper. So here in New York, as we've already talked about, the New York Law Journal. Other states have their particular newspapers. Sometimes it's a news weekly. In Connecticut, it was the Connecticut Law Journal. And that's where you would find unreported cases. Now, sometimes very new cases start in the New York Law Journal and then get published because they're precedential. So then they have other citations like we saw with that other case as well. There is one source for federal unreported cases. So again, not precedential cases, cases that stay unreported. And that's the Federal Appendix. And that gets very confusing for first years and I think for more experienced people because it looks official. There's actually a book, the Federal Appendix. We have them down in the library. Basically what happened is all of these unreported federal cases were on Westlaw, and Westlaw saw, oh, look, all these attorneys love all these unreported cases because, of course, you all want to find cases on your issue with your facts. So that's why attorneys love unreported cases. At least they can cite to something and say, hey, look, the judge did it here. You should too. Even if it's not mandatory, it might be persuasive. So Westlaw saw how popular these unreported cases were becoming online, and West decided, oh, we can make money off of this. Let's publish this in print, good old-fashioned bound volume, and sell them to whoever will buy them. And sure enough, we law libraries bought them. So we have the Federal Appendix. At least on Westlaw here, this case was not selected for publication. So at least you get a notice. Question?
So I'm assuming that this whole process from deciding what's going to be, this is a cynical view, what's going to be published, non-published, to, I guess, the commercial publication, non-publication, non-published opinions becomes either politicized or affected by this commercial interest, big business to that extent.
I haven't had that sense. It's certainly possible. I'm as cynical as the rest of them. But as I understand it, as I pointed out here in New York anyway, we have this Law Reporting Bureau. So this is some division of the judicial branch in New York that follows these rules. And there's actually, you can see there's a reference here to the judiciary law, so statute, as well as the regulations. And here are the list of aspects, considerations. As I understand it, the federal judges or some part of the federal judiciary make that decision. I haven't certainly read about anything that suggests that they are very overly publicized. This article suggests that it's more of, well, you can read here some of the considerations that might come into effect. And some of it is, I mean, this article does suggest that it's, in a sense, political, not. So, sure, that's certainly possible. I don't think that that is the primary basis.
I was just thinking like an industry, like a friendly circuit, like the Fifth Circuit could grant, like say, hold no standing or, and grant a motion to dismiss and then not feel too comfortable about it, but know that it could lead to a floodgate of lawsuits or something in this particular industry. And then, so they just make it unpublished, and of course the industry is going to want Westlaw to publish that, I guess, in their non-published opinion, or they want that to show up in commercial databases, so the cited you more. It's a friendly opinion that's unpublished. I don't think there's collusion going on, but I think just, a restraint of judges going like, oh, well, I don't want to grant this huge, claim to a plaintiff, and so they dismiss it, and they unpublish it, and then industry obviously holds that up and hopes to decide to more and more.
Well, I mean, certainly in industry, if there's a newsletter or a publication about the law in that particular area, that publication, and even if that publication has a particular point of view, they certainly would reference this case, hey, this is really interesting, and Lexis and Westlaw might pick that up. Yeah, it's certainly possible. I have not, as I said, I haven't read anything that suggests that that is particularly common or prevalent, but I certainly wouldn't rule it out as a possibility. I mean, read this article. It does give you some sense of not so much the industry aspect of it, which is an interesting one, but sort of the judge's viewpoint and how it affects what's published, what's not published, and then even talk a little bit about what cases are accepted. Matt, did you have a? Okay, we're going to finish up before we take a break by looking at the parts of a published case, because we are going to be talking about using these parts in order to more effectively research cases. So I pulled up the case, a favorite here, Fisher v. Lowe, and it's a favorite only because you might notice that it has an unusual format. So the synopsis, the summary: a wayward Chevy struck a tree whose owner sued defendants 3. He sued car's owner, driver 2, and insurer for what was due. So someone had a good time putting this in verse. And what was particularly kind of fun is if you scroll down to the opinion. And actually, this is where it started. So the opinion. We thought that we would never see a suit to compensate a tree. And I won't read any more of it because you all can read it yourself. So kind of silly or fun if that's your sense of humor. Well, you don't have much of a sense of humor. Actually,
not when it comes to.
So the judge wrote this. I mean, if you read the opinion, it actually is a kind of silly case. But I actually visited the publication center of West many, many years ago. And the judge wrote the opinion in verse. And then the people who create the headnotes, which we will be talking about, and the synopsis, which are the people at West, saw this, so they did the same thing. And apparently the supervisors of these headnote and synopsis writers were not amused because they think the law is a very serious business and they should not be playing around with it. Those of us who spend time teaching this stuff actually think it's kind of fun, but everybody has their own opinion, which is what makes life interesting.
Probably means where cases are discussed.
So the point here is not so much debating the merits of poems opinions in verse. It's to show you the different parts of the case, in whatever format they take. So the synopsis, the summary, again, this is written by West, and if we look at Lexis, the summary is written by people who work for those companies, so these are not official parts of the opinion. We then have headnotes, and we will be talking about headnotes in detail after the break. And so basically headnotes, and we'll talk about what they are in a moment, also published by, not published, authored by people who work for Lexis or West. When we finally get to the opinion, that is the actual part of what we're reading here. That is what we refer to as precedent using stare decisis and all the concepts we've been talking about this morning. And we will be using these different parts of the opinion, as I said, talking about them and how to use them to more effectively research after the break. So, researching cases. Obviously, we'll talk a lot about Lexis and Westlaw, but there is, of course, our good friend Google. And you can find actually quite a bit of case law on Google Scholar. So you have to remember to Google Scholar. And then we talked already about articles, but here's that other radio button for cases. And Google knows I'm in New York at the moment, so it highlights New York. So I can choose my jurisdiction here. And what I'm going to do to save you watching me type is jump over here to where I have already run a search. In Google Scholar, in the case law, I chose my jurisdiction as New Jersey. Some of you might remember from your FLS, I think it was last year, Dean Selby talked about an example on researching drunk bicycling. And I actually sat in on that class, and she was typing away, and she typed in drunk bicycle, and apparently the leading case is State v. Johnson, which comes up beautifully here on Google. However, as I keep on warning you, computers are stupid. Even Google isn't that bright. Because if you type in, and I don't recall if I showed you this before, but if you type in a slightly different way of thinking about that concept, same concept, right? Drunk bicycling, drinking bicycle. It takes you a while, if at all. I don't know where State v. Johnson is, and if that's the leading case, you would have to go at least to the next page. I'm not even sure if it's there to find State v. Johnson. And again, because Google doesn't realize that drunk bicycle and drinking bicycle are really searching the same idea. So beware. Actually, interesting Lexis and Westlaw are much better about recognizing that different forms of a word are really still the same concept. I'm guessing because it has more, Lexis and Westlaw, more experience in developing their natural language algorithms to understand what we attorneys are thinking about and the idea that those really are the same thing. So Google Scholar is great, again, to start with, just to throw in your words. It's free, it's quick, it's easy. We all love Google, but be very aware. And amongst the many other, that reason, as well as many others, we're now going to get to some of the tools that Lexis and Westlaw provide for us to make case research more effective and more successful. And the main tool for that, as I mentioned, are headnotes. Anybody remember from first year what headnotes are or do?
Narrow down things by topics and group them all together.
So they group them all together by topics. That's a good way of describing it. I like to think of headnotes as the originator or precursor of what we all do online with hashtags, right? If you go on Facebook, Instagram, right, you put in hashtag. How many of you are Game of Thrones fans? Totally crazy over the dragons in Game of Thrones. And sorry, spoiler alert, the whole blue fire thing. I can't believe we have to wait till 2019. But anyway, so if I need to fill my need for blue dragon or blue fire dragons, I'm going to go to Facebook or Instagram or whatever I feel like and hashtag Game of Thrones. But of course, because I want to narrow down a little bit, I want more than just Game of Thrones, although I could spend plenty of time just on Game of Thrones. But hashtag Game of Thrones and then hashtag dragon, because I love the dragons. I think the dragons are the coolest. And then maybe hashtag blue fire. So I've got those different, that kind of hierarchy of my Game of Thrones passion. So really the headnotes work the same way. They're just, as I said, old-fashioned hashtags. And on Westlaw, instead of a hashtag, they use the key symbol. So, like I said, Westlaw should I don't know if they could try to claim ownership of this whole hashtag concept, but it's too late now. Anyway, moving on to head notes and why they are so useful, why you care. Well, really kind of the same reason you care about using hashtags on whatever your favorite social media site is to find cases on a particular topic, exactly what you said, Matt. So I am looking at the Aetna v. Davila case here. You might remember we saw this reference to the Supreme Court in a bunch of the different secondary sources that we looked at way back in the beginning of the course when we were first investigating our client's topic regarding liability of HMO. So we see it's the Supreme Court, we see it mentioned a few times, we should have written it down like, check this one out eventually. So here it is. So how I use these head notes, essentially the same way I use a hashtag. I scroll through and see which one is going to be of interest to our client. And so here, number 8, I see insurance. Okay, we know we're holding HMO is insurance. And so the text here of the head notes basically explains the point of law. So what head notes are doing, they are explaining the different points of law within the case. They're giving me numbers. If I click on 8, I'll jump down into the opinion where this particular point of law is discussed. So here's the text explanation. Individual brings suit complaining of denial of coverage for medical care. Sounds pretty good, right? On the right-hand side, below the key symbol, we see the hierarchy of the topic. So the standardized terminology used for the topic. So the problem with hashtags I find, social media is it hashtag Game of Thrones spelled out, or is it hashtag GOT? You have to try both, right? Well, what, Wes? Pardon me?
It's GOT.
It's GOT.
That gets you the better stuff.
Okay, thank you. So we have that set. So Sibel is the authority for hashtag Game of Thrones, or GOT, excuse me. The Westlaw topic system is the authority for the Westlaw system, topic system. So the official name for the insurance topic is insurance. And then we see the hierarchical breakdown. So within insurance, there are a whole bunch of different topics. There's what law governs. And then within what law governs, there's the whole issue of preemption, which we've been talking about a lot, application of state. And then even within that subtopic, there are other smaller divisions, particular laws, employee benefits. Ooh, look at that, even within that, healthcare benefits. So it just gets narrower and narrower in terms of topic. And the beauty of this system is it's universal. So just as we've had a ruling from Sibel on Game of Thrones, it's GOT, the official topic breakdown for this particular area of insurance law is what law governs preemption, and then finally, healthcare benefits. Just to make sure you have a good understanding of that, I'm going to go over here to a different tab in Westlaw, and we're going to look at the Tools tab. And the reason we're going to look at the Tools tab is we're going to look at the West key number system. So this whole topical system is spelled out in this Tools tab, and it's sometimes just a good place to look just to get a sense of how West categorizes your overall topic. So you can actually search this. I don't recommend this as a way to search cases, but it's actually just an easy way for me to show you what this system looks like. So if we were to type in one of the terms of interest, health maintenance. So we've been talking about health maintenance organizations. This is why I try to type things in. Organization. Here we go. What this search does is this will let me know the different overall topics and subdivisions where my term appears. And one thing, very important thing you should notice here, and we'll see this again when we go back to our Aetna case, is that sometimes a particular phrase or case can cover, or even legal concept, again, we've been talking about liability of HMOs, can be covered by different topics. So we already talked about insurance. We saw that in Aetna, and sure enough, there's the topic that we were just talking about, employee benefits within the insurance topic, or excuse me, healthcare benefits within the insurance topic. But here's another topic that kind of makes sense, might be of interest for our client, health, right? And what we see here are the different topics, so the health topic and key numbers that come within the health topic that has our particular search term. So here's one, health maintenance organizations. So just be warned, if you click, so as I said, it's perfectly fine to look at this topic tab. I don't suggest this as a research tool. I just use it to get here to show you the topic. And the way I'm going to do that is by clicking on it. Now when you click on it, you get head notes. And we'll talk about why this might be useful in a different context. But what I'm doing is I'm getting to the topic hierarchy, essentially the table of contents. So within the health topic, I'm looking at the so actually let's go to the health topic. So within the health topic, I'm looking at the malpractice and negligence subdivision. And then within that, I'm scrolling down and I actually might see some other key numbers. Now notice our subtopics are also assigned numbers. That's why the system is called the key number system. Number is useful to help you identify it, but it's not really necessary to know. So we might see preemption, 607 is useful. We already saw 785 talks about health maintenance organizations. If we look under persons liable, so looking at our table of contents for other possible useful key numbers, in this particular case, not that useful, but if we look at the broader topic, we see, and we were to scroll either up or down, we see we might find others as well. So again, using this topic list, I don't suggest as a standard strategy, but sometimes if you want to see what your topic looks like, it's there. If you never use it, you wouldn't be missing much. So let's go back to our Aetna case. And as I mentioned, if we look at the other head notes, we discover, oh look, here is the health topic. And sure enough, this health topic does go through and does use that preemption subdivision within the health topic, key number 607. Interestingly, this particular case, Aetna doesn't use the other one we looked at, 785, health maintenance organizations. So not every case will use every single topic that you think is relevant. Okay. So are we all good on what head notes do? Now the beauty, as I said, of this system is the universality. So I can now take a topic and head note of interest and find other cases that use that same topic and head note, which means they discuss that same point of law. How do I do that? Well, if I'm within a case, I find whichever topic, or maybe I'll do this a couple of times that I think is of interest. So we identified insurance, and we decided healthcare benefits might be interesting. So I click, and I can click on any of these levels of topics. So if I think preemption is where I want to go, I can do it here too. But let's stick with the most detailed one because we really are interested in healthcare benefits. Now just be warned, what Westlaw does is it puts us in the jurisdiction from whence our case came. So remember, Aetna v. Davila is a Supreme Court case, so I am in the Supreme Court jurisdiction. So what I am looking at are head notes from other cases that use that topic and head notes. So use insurance and healthcare benefits. But I'm only within the Supreme Court, which is important. Of course, the Supreme Court is important, but remember, I may want to see lower court decisions. I may want to see New York State decisions as well as federal decisions. Super easy to do as long as you're aware. Once again, being aware of what you're looking at is really important. I just changed my jurisdiction. Again, once I know I need to do that, it's ridiculously easy. So I change my jurisdiction to whatever I am interested in. I can specify to New York. Maybe I want to do all states, all federal. And again, what I get is a list of head notes. a list of cases that use my topic and key number or subdivision, or topic subdivision. And you see the listing there. Okay, so let's go back. Actually, let's not go back quite yet. So here's our listing of cases that use the insurance topic and the healthcare benefits sub topic. One other thing I can do, so I now know we are talking about insurance, we're talking about healthcare benefits, excuse me, with respect to preemption. I'm interested in that whole denial of care issue, right? So I have a search within results. Now bear in mind, because what this system does is goes by the head notes. All I'm searching are the head notes. I am not searching the full text of the decision, but even searching the head note text can be interesting. So I'm going to keep it simple, so you don't have to watch me type, but you can type in any kind of, remember you have to use terms and connectors with search within results, but I can type in any type of terms and connector search. And if I apply my filters, I get those cases within the jurisdictions I selected that use my topic that have my search terms. So alleged wrongful denial of benefits, denial of coverage, denying coverage. So at least these head notes look like they have narrowed down to a whole list of cases that might be worth looking at. Again, this is not a tool that you will always have to use. You might find cases perfectly fine by just doing a regular keyword search. But this is a good tool to know about, again, depending upon your issue and the complexity of that issue. So one other tool. Now this, okay, so this tool that we just talked about depends upon you already knowing a case, right? We looked at the head notes of the case, we found a good head note, clicked on the head note. But you have to get that. This is called the one good case method. We librarians like to give names just like lawyers do. But you have to get that first case, right? And probably the place you're going to start with a keyword search. So that's one way to get a good case. What are some other ways to get good cases that we've talked about? Yeah, secondary sources. What else? Annotations, notes of decisions, and statutes. Absolutely. And of course our keyword search. We could do our keyword search on Google, get our good case, and then plug it in to use the head notes, however you find that case. So another tool, another way of using these head notes that's slightly more sophisticated is doing your keyword search. But before you even dive into your results, before you even look at a case, well, first narrow to cases, that's important. So looking at your list of cases, you can use the key number filter. So we used to filtering by jurisdiction. We already started filtered by jurisdiction. But using your key number filter once you're in the case, once you're looking just at cases. What this key number filter lists for you are the different topics that are found in the cases that are in your results. So all these lists of however many cases there are, these are the topics that are used. So you can either scroll through, or we already have a sense of topics of interest. So we know that the health topic might be of interest. I can filter just by the entire health topic by clicking on add, or I can be a little more specific within the health topic. So maybe I want that overall topic of malpractice, negligence, or breach of duty. So I could add that, or I could get even more specific. Maybe I want to get more specific to persons liable. And maybe I want to add health maintenance organizations, or maybe I decide, nah, you know what? I just want the broader subtopic. So I'm going to go back to the health topic and I'm going to add that. You can go either way. And as I think they still say on the late night commercial, but wait, there's more. I did not even have to close that. I can add other topics. So I can go down to insurance, and again, I can add the whole insurance topic, or I can scroll down, or drill down, excuse me, to more specific subtopics within my insurance topics. So what law governs? Maybe I want to drill down particularly to just healthcare benefits. So I can add that. And then now I've got both of those, and then I just always have to remember to tell Westlaw to apply my filters. And now I've gotten far more specific. This technique of using the topic-oriented search, the headnotes, whether you do it through the search the way your search results the way I've just done, or going into a particular case, your one good case, and clicking on the headnotes. This is going to tend to be more useful for when you have a more complex issue, when your issue revolves more along the point of law rather than fact-based. Fact-based tends to be much easier to find cases when you can just type in your keywords. The classic example of that is dog law. Anything, search for dogs, you're going to find cases about. You search for dogs, you're going to find cases about dogs. Is what I said always going to be true? Of course not. And again, this is not something I suggest you have to use all the time. This is for when, if you do your keyword search and you're just getting maybe some relevant cases or cases that are kind of in your area but not really discussing your issue. Again, these are tools for your toolbox. Another tool here. Any questions about filtering by headnote or by clicking on the key number? I should mention that these techniques are on your techniques handout. Again, also on the TWEN site for you to refer back. Another tool here, which we've talked about with regard to secondary sources, is sometimes it's interesting to change the sorting. So we can sort by the most cited. So which cases have been cited the most times from our results. Not surprisingly, Aetna is on top because it's a Supreme Court case and one of the leading cases in this particular area. So another technique or tool for our toolbox is the advanced search. And to understand how this works, let's take another look at Aetna at the parts of the case. So we have the synopsis or summary, and then we have what Westlaw calls the digest. It's really the headnotes. So it's the text here, the description of the headnotes, and the actual hierarchy of the topics. So the summary and this, what Westlaw calls the digest or the headnotes, are actually really focused on what the case is about, right? Because the summary summarizes it, and the headnotes are the different points of law discussed in the case. So if you are finding you're doing keyword searching and you're getting a lot of irrelevant results because your search terms are coming up, but they're coming up mentioned in a totally irrelevant or not interesting way, you can tell Westlaw, just search those parts of the case that tell me what my case is about. And the way you do that is on Westlaw, you narrow, again, to use the advanced search, you need to narrow to your material type. So we're searching cases, so we go to cases, and then we go to the advanced search, And what you see are the different parts or fields of the decision. And what we have here, we have a headnote field. But if we scroll to the right part of the listing, we see we can search either the synopsis or the digest. Again, the digest is just all of the headnote information. Or we can search them together because Westlaw understands that that could be really useful. So this is what I call the synopsis digest search. Not a very original name, but it's a useful tool. So we can use the synopsis digest search in conjunction with a regular keyword search. So up here, I could search liability HMO. So I get that I am searching those terms throughout the entire case. So the synopsis, the digest, the entire opinion, any dissenting, concurring opinions, the whole thing. And then I can say, but also just within synopsis and digest, I want you to find for me, and we will do a slightly more sophisticated search by way of review. So I want any form of deny, denial, denied, denying within the same paragraph as cover. Again, any form, coverage, covering, or benefit, or care. Because as I've done my research, or as we've done our research, we've discovered that sometimes it talks about denying coverage, or denying benefits, or denying care. So, very sophisticated, advanced search. Westlaw puts it all up there for me. Let's see what we get. We're narrowed to New York. Hopefully that will work. We could do search within results further if we want. We could narrow. We've already narrowed by jurisdiction, but if you hadn't, you could narrow by jurisdiction. You have all of the different filters that are typically available here. Any questions? And one filter I should point out, because it relates back to our conversation before the break, if we wanted to, for whatever reason, you can actually filter here in New York, you can filter by department. I would suggest not doing that because, again, you want to be aware of what all of the New York courts are saying about your issue. And again, if it's not addressed in your department, you need to know how it's addressed in other departments. You also need to know if there's a conflict. So you can say, hey, this case was decided in the second department. That's why we're going to follow this one. So I would say as a rule, you don't want to narrow by department, but there may be a circumstance where that becomes useful. So it is possible. Questions? Okay, a couple of other tools on Westlaw for searching cases, and then we'll move over to Lexis. And those tools, again, are within our advanced screen. So here in cases, we go to advanced, and they're just different fields. It used to be, even doing keyword searching, finding a case that talks about a legal definition. Now, as I've said before, and not very grammatically, law is words, and the definition of words matter very much. So cases that judicially define words, where a judge says, this is what this term means, can be very important. It used to be keyword searching. That was really difficult to find because the judge typically, in his or her opinion, wouldn't say, this word is defined as, so you could type in your keywords definition within the same sentence as whatever your word is. The judge would just talk about either the meaning or use all sorts of different ways of expressing that concept of definition. So what West developed way back before Westlaw is words and phrases. And you can actually find a words and phrases volume in the old-fashioned print digest. Or you can search the field here on Westlaw. So if you have a word that you need to find what that word might mean. So if we wanted to find out what malpractice might mean, we can type it in. The words and phrases are already limited by jurisdiction. And again, you'll notice Westlaw puts it up here. Now I haven't put in anything about any other aspect of our issue, so this is just cases that define the word malpractice. So it could be any type of malpractice. So that's one other advanced field search you could use if you find you need a definite cases that talk about definitions of terms. It could be that you are practicing before a particular judge, either state or federal. One of the other parts of the decision is it tells you who wrote the opinion, right? So one way to use the written by field is if you know you're appearing before judge, whomever it is, you go to your jurisdiction, Louisiana, New York, and you type in your judge's name. So here we are already in federal in New York, so I'm going to type in Judge Sotomayor. Oops. Again. And yes, I spelled it right, always important, obviously. So I will see the opinions. Now this is any kind of opinion since, of course, Justice Sotomayor is at the Supreme Court, so she might have written concurring or dissenting opinions as well, which would show up here, as well as the majority opinions. And it will also pull up cases when she was a district judge because that's the jurisdiction that I've indicated. Any questions? Okay, and if there are any research junkies among you, on the back of your handout, we're not going to go over this because this is only if you're really a research junkie, and if this really appeals to you, you should consider being a librarian. The really advanced, we've been talking about advanced, this is really advanced, and as you can see, it's pretty involved, but it's a way of using that numbering system I told you about for topics and headnotes. It's a way of using those as search terms to really super narrow in on your search. Again, don't worry about this. I put this in there because I am a research junkie and I think it's fun, but I know that you all might not. I would say that the two most important techniques we've talked about so far on Westlaw are once you're the one good case and clicking on the headnotes, and I would say even more so my favorite tool is doing a search, looking at my case search results, and using that key number filter. Those are the ones I would encourage you, make sure you really understand. Questions? Okay, so we are going to do a workshop. How are we doing on time? Not so great. Pass this around. If y'all don't mind, it is getting warm in here. Thank you, Alex. I should have split them up. So, to practice using these techniques, we're going to go off topic a little bit, or change our topic. So, here's your question. As a lawyer, can you be sued if you forget to update, and the law you relied on is superseded? So again, as with all topics, a good idea to do some issue spotting. So let's do a super quick issue spotting. Who are we talking about? Lawyers, also known as attorney. Okay, the what? Malpractice. Anything else?
Liability.
legal theories under what? Any other legal theories? Again, there's no magic to what column you put it in as long as you put it somewhere. Okay, so what searches are you going to try? Put fingers to keyboard, what you're going to type.
Attorney, liability, cite, superseded precedent, cite exclamation point.
Anybody else have an alternative?
Is it, since we know it's going to be like a model rules, I don't know what that's what a reference that is, but in ADA or.
Well, we're not searching, we're looking for cases.
So, but wouldn't any case involving that involve the model rules of professional conduct? Like, I mean, if we're
It's
looking
pot-
for-
It's not,
Yes.
It's not discipline, it's law. Right?
Certainly.
Well, yes, the model rules might be implicated in terms of what standards the attorney should have been following. But if, heaven forbid, and this shouldn't happen because you're all here, you represent a client and you forget to update, and you get sued, you're going to be in court. So you're going to want to find cases.
So wouldn't I would assume most of those cases would cite at some point the ABA model of professional conduct. I may be wrong, but I would think that. I just didn't know if that would be research a little better.
It might, but you need to find what the standards are. You might want to start your research in the model rules to see if they spell out what the standards are with regard to citing superseded precedent. But ultimately, you're going to want to find what the case law is for to what extent, what the parameters are. So you're going to want to, the answer is you're going to want to find both. But the exercise for now is looking at the case law portion. So what would be an alternate search?
Malpractice, fail, exclamation, current law.
Okay. All right, let's spend a couple of minutes going through the workshop, the questions in the workshop. I think a couple other of you found cases using the attorney-client topic. I don't know if you got that far. So let's do it this way. So you at least got into the topic, and we'll talk about issue spotting in a moment, but let's take a look at that key number system on Westlaw, and having identified, and for those of you, do you recall that did see cases using the attorney-client topic, do you remember around what numbers you saw? James, you look like you're thinking about it.
Yeah, I think I was around like 112.
So 112, so in the 100s. So first thing I want to explain a little bit about the numbers. Again, you don't need to use these numbers, but just so you don't get confused by them. So 45 is the number assigned to the topic, the overall topic, attorney and client. Going back here to this overall topic list, we see the topics are numbered, starting with 1 abandoned property to 400 something on zoning, and all the numbers in between. And so attorney and client is just assigned 45. So that's all the 45 is just that topic number. Within the topic, then the key numbers or the sub-topics get assigned numbers. And so James found something in the 112 area, you said, and 112, and Matt found something in the 105. So if you find something in the general area, or even if you don't, you can come to this topic list, and this is one good use for it because it's a table of contents, and see where the one number you found, even if it's good or not good, and then numbers around it. So Matt found 105 in general. Typically a good idea to look at that because it's not specific enough to know whether it's relevant, but it might be relevant. So you kind of have to, unfortunately, because it isn't specific enough. But scrolling down, so in general, elements of malpractice or negligence, action in general, that might be interesting. So this whole duties and liabilities subtopic, sound promising. Scrolling down, instruction, skill and care required, again, might be useful. Scrolling, continuing down. 112, conduct of litigation, and then 112.50, research and knowledge of the law. Because after all, and this gets to our issue spotting and the hint I gave you about being a little less specific with regard to your facts. So, I'm both pleased and a little bit disappointed that you didn't want to search the words updating, but really that's good. That's just a joke. But you did identify that as citing superseded precedent. But what is that a part of in terms of what attorneys do? Research. Now, you didn't know that in advance, but in terms of thinking about your issue spotting and the terminology you're going to use, think about broader categories. Just as I was having the conversation with Stan in our first class, he was talking about wanting to research heart problems. And I said, yeah, it's worth a try, but you may need to be less specific because there may be cases about other sorts of medical issues that are totally relevant to our legal issue. So likewise, there may not be cases that talk specifically about updating precedent, but there may be cases that talk about doing research properly that are clearly, I think, going to be relevant to answering this question. Okay, so we now have some topics and key numbers to work with. Everybody comfortable with how we got there? Amy, you look.
Yeah.
Can you identify the kind of not part?
How did you get to the whole list of the key numbers? I got to it through clicking on through a case. Is there an easy way to get through?
So if you've already identified a topic, so is that your question, identifying the topic, or just actually looking at the list once you have a topic?
Yeah, looking at the list.
So once you have a topic, and here on the home page of Westlaw, tools, the very West key number system. And then you've already identified the topic, so you click on that topic, and then you see that list.
When you do jurisdiction, when you limit the jurisdiction now to New York, it's going to cut out all diversity cases.
If you limit it to state,
Right.
but if you have federal, if you
But
include
then-
related federal,
Right, there's no way, and I think I know the answer, there's no way to get federal cases applying New York law. So I can have the Ninth Circuit applying New York law, I
Okay, so I don't think this answers your question, which I will try to do, but in the jurisdiction choice list here, you choose whatever state and you include the related federal. So that's going to include New York federal courts.
But then or just any, I think that includes any federal courts, right? Because when it goes, at least I was finding stuff from like Illinois.
But it depends on, if include related federal, that's,
Okay, it's different than all federal.
is different than all federal.
But if I wanted, you can't do it to all federal courts applying New York law, which I'm pretty sure.
Implying New York state law, no, because there may be some case that involves some federal issue.
Right.
You're basically looking for diversity cases, right?
Yes.
Yeah, not that I know of. The include related federal is as close as you're going to get, and typically if it is a state law issue, many of the federal cases will be diversity cases. But so in this issue,
Just like when you say limited jurisdiction to New York, which I think obviously is smart for once you have your topic, you're slashing out potential diversity cases.
not this search, no. Because I've got include related federal. I also have Supreme Court, but that shouldn't matter. That's going to have diversity as well as federal issue.
I assume there'll be some cases in diversity that will decide not to apply New York law, and there'll also be cases that you'll find that will say applying the federal court in diversity will apply New York law.
Well, if it's under Erie, if it's a diversity case, they have to apply New York law.
So I guess there's no way to get just the cases.
Right, I know. My issue is whenever California sues Oregon on a New York contract, for some reason they're California District Court. There's no way to get that in. Right.
Oh, I see. A federal court outside of the state applying a different state, a state that it's not in its law.
Delaware District Court. When I sue the stock company. I'm pretty sure the answer is no, but I just
Not that I know of. I would say that's fairly infrequent. That you're in a California court applying New York law. Well, I suppose you could. I take that back.
I
But
would say Delaware is New York would have a lot. I mean, again,
or vice versa. Well, vice versa because Delaware corporations.
Right. No, absolutely.
Yeah, no, you're right. You're right. So I do take that back. So yeah, to be safe, you'd want to do all federal. Again, then it depends upon your issue. If the issue is taking our Delaware example, your issue is a Delaware corporate law issue for Delaware state law. Corporations like to incorporate in Delaware. That might be an instance where you want to do all federal because the district courts. Let's go back and look at how to use some of the case finding tools on Lexis and Bloomberg. So here on Lexis, if we use our one good case approach, so we have our ethnic case, again, that we've learned from secondary sources or elsewhere. Lexis has similar parts of the case. So Lexis actually, nice thing about Lexis, it identifies some of this terminology that you might want to use for you. So we're just talking about choosing terms for your research and learning from your research. So Lexis provides this assistance in core terms. Lexis, instead of calling it synopsis, it calls it summary. And then Lexis has its headnotes. One thing to remember, as I think you can see, is Lexis headnotes are very different than Westlaw headnotes. It's like Coke and Pepsi. They don't share their formulas. Lexis, and Westlaw do not share their headnotes. And you can see the the structure of the headnotes are very different. With Lexis, it's just one string. So if we scroll down a little bit, we can see here ERISA federal preemption. And what we see is under actually pension and benefits law, ERISA federal preemption. Another possible relevant headnote, ERISA civil litigation. Here's healthcare law, managed healthcare. So again, the structure is quite different. And the way to take advantage of these headnotes, let's find one that we like better, is basically, as we discover, to click on whatever level it is that you want, and then here on Lexis you just tell it to go ahead and get the documents. And what Lexis will do, as we saw with Westlaw, is it will pull up cases that use that headnote. At the moment, I have not limited my jurisdiction, so this is from everywhere, but we can limit our jurisdiction again on either end. So I could limit it to Second Circuit in New York with our filters. Another tool here on Lexis, if we do just a term search, again I am using the word liability because that is crucial for our issue, and I limit to cases Lexis provides us a way to limit by practice areas and topics here in the filters. Lexis also provides kind of useful, I'm not really sure, I kind of go back and forth about this. In the About This doc, when you're looking at a case, so we're looking at our Aetna case, if you do find a relevant case, Lexis provide these topic summaries. And I'm kind of on the fence with these because clicking on topic summaries, I say, oh look, pension benefits law, suit to recover plan benefits. That sounds pretty useful. But yet, looking at this, and interesting because this did come from Aetna, it only covers one part of the issue. So you need to be very careful is all. So this part that it discusses, might be useful to give you hints as to other cases. But it really is only a start. If you do find this topic summary to be helpful, you can actually search them here on the home page just by typing in topic summaries, and then Lexis brings you to an advanced search that just searches those topic summaries. So if you do find them useful, that's a way of taking advantage. And I should have mentioned in terms of using the headnotes. And again, these headnotes, totally same concept in terms of topic organization. So if we do get the documents that mention federal preemption, I mentioned obviously the jurisdiction filter. There is, of course, search within results. So again, if we wanted to search for our denial within the same paragraph, and again, you need to use terms and connectors. So care or coverage or cover or benefit. It's a way of using the various filters. So taking advantage of the headnotes and taking advantage of the search within results. Lexis, like Westlaw, also has an advanced search. So in going to cases, taking a look at the advanced search, it again lists the document segments or fields. And you can see what they all are. I think we've gone over this before. Here, this diagram on the right to see what the different fields actually are. So we can just search headnotes, just like we did the synopsis and digest search on Westlaw. We can just search by the judge that wrote the opinion. So again, like we did earlier when I searched for Judge Justice Sotomayor, written by, you can actually on Lexis specify particular types of opinions and which judge authored them. So we've got the main opinion of the case. We also can search by concurrence or dissent. Any question about Lexis headnotes and fields? We're at the point now of rinse, wash, rinse, repeat, I think is the expression, where same concept just looks slightly different. So here on Bloomberg, the same concept is going to apply with regard to headnotes. So if we pull up the Aetna case, right here, and hopefully Bloomberg will get there, making progress. As we scroll down, again, as I mentioned, same concept. You can click here on the headnotes and see other cases in which this particular headnote of Bloomberg's applies. Again, Bloomberg headnotes are going to be very different than Lexis or Westlaw's. One interesting feature on Bloomberg that isn't available on Lexis or Westlaw is this points of law. And what this does is Bloomberg will identify in the case that has this points of law feature the different points of law that are highlighted. And what you can do if you identify a particular point of law of interest in a particular case is to click on it. And Bloomberg will pull up other cases that talk about that same point of law. If you are interested, you can also go here to the Bloomberg homepage, if you like this points of law feature, and you find it here on the home page. And what it allows you to do is to search the cases for particular points of law. So if we were to enter our search terms ERISA/P preempt, again a terms and connectors search, what Bloomberg will do when it gets there is identify cases that in its points of law use our search term. Finally, here on Bloomberg, again getting back to the home page, eventually in looking, if you just wanted to go directly to search court opinions rather than filter after your search, Bloomberg does have an interesting additional filter that you can look by industry. By browsing the list, you can narrow your cases by what industry are discussed in or covered in those cases. And last, as we've discussed, is FastCase. So again, searching the online resources, we would bring up FastCase, get to it here. Then it always takes a little while to come up. There we go. So if you are a member of the New York Bar Association, you will have access to the New York materials on FastCase. And if you do, for searching cases, once you get to FastCase, I highly recommend you switch over to the new FastCase, because this eventually will be the only thing that's available. And again, waiting for that to come up. And here's what the new FastCase 7 looks like. And if you wanted to do a search on FastCase, so for example, LIAP, now I'm using the star instead of the exclamation because I checked here in help to learn my different search connectors. Remember, they're not always the same. So /50 within 50 words and in quotes, managed care, close quotes. And I'll tell FastCase to go. Now, as we will see in a moment or two, FastCase looks a great deal different than we are used to with Lexis or Westlaw. Let's take a look at it specifically for cases. So I'm filtering by cases. And you can filter by jurisdiction and court as well here on the left. But what we see here is something you've seen in other websites, a word cloud. And what I like about this is it gives me ideas of different terminology that's used in my search results that I might not have think of. So for instance, maybe I want to use health plan instead of or in addition to managed care. And if I click on it, I can essentially do a search within results. So I'm now searching within my results that have used managed care for the cases that have talked about health plans. So that's one different thing on FastCase. Another one is this interactive timeline. This timeline is essentially telling me how frequently the cases in my search results have been cited. And the gray circles tell me how frequently they've been cited in the entire FastCase databases, and the sort of light yellow color here, how many times my case results have been cited in these particular results. If I want to narrow down to a particular time frame of this interactive timeline, I can just highlight that here. So for instance, I've highlighted around 2004. So I see that I can now identify our Aetna case as being in my search results and seeing that it has been cited quite a bit. The other thing this interactive timeline does is it tells me how frequently cases not in my results but that are cited a lot in my results appear. And that's what this foresight feature is that we also see here on the right. So these cases did not come up in my results because they didn't contain some of my search terms, but these cases have been cited a lot, so FastCase is guessing that they might be relevant. Okay, so that are the case features that we've talked about. Make sure to ask me if you have questions about Assignment 4. Again, part of Assignment 4 we haven't discussed yet, and that will be part of the other makeup, and that is detailed on the home page of TWEN and also in the email that has gone out.